Paul da Costa, thank you so much for joining me. We're here to talk about Level Insurance. My name is Justin Leto. I'm the CEO and co-founder of Level Insurance, now called LevelEsq as we've rebranded. We're going to talk a little bit about your experience using the Level Insurance product and the claims process. But before we do so, will you tell us a little bit about yourself, about your practice, please?
Yeah, good morning, Justin. Great to be with you. Good to see you. So as you said, my name is Paul da Costa. I'm a partner with the firm of Snyder, Sarno, Daniello, Masseri, and da Costa. We're based in New Jersey. We have offices throughout the state, and I head up our firm's medical malpractice and personal injury department. I'm a civil certified trial attorney by the Supreme Court of New Jersey, and I focus my practice largely on medical malpractice cases as well as other catastrophic injury, personal injury cases. I started my career actually doing defense work. I did medical malpractice, some products liability, mass tort, and then converted over to the bright, sunny side of the V on the docket, shall we say, and have been doing plaintiff's work for several years now.
So, Paul, your law firm, Snyder, Sarno, Daniello, Masseri, da Costa, you guys have used Level Insurance for multiple different kinds of cases, mostly medical malpractice is what I've heard from you. But I think a lot of lawyers, when they hear about Level Insurance, they think, okay, this is a great idea. I can insure my case. I'll make sure that if I lose the case, I have some backstop. But a question I often hear from folks is, what's your claims history? Are we actually going to get paid? And how's that process going to look? Because I think especially as plaintiff lawyers, knowing how we deal with insurance companies very regularly, we're a little skeptical, right? Like we think, okay, is the insurance company actually going to be there when I need them? I think people have that feeling oftentimes about all types of insurance. And so for us, it's important that people understand that when they use Level Insurance and they insure their cases, that if they have the problem where they lose their case at trial, that we're actually going to be there, that we're going to do exactly what we said we were going to do. So for your firm, you've had several policies that you've bought with us and you've been a great customer. Can you tell us a little bit about your experience with the claims handling process and how that went for you? Because I want everyone to understand that when they use Level Insurance, not only are they going to have the feeling of protection, but when they actually go into the courtroom and try the cases and they lose, they're going to be protected immediately by the policy.
Yeah, so I mean, you hit the nail on the head. Everyone's skeptical about insurance companies. If you do what I do, what you and Larry used to do. But I can say, honestly, that it was the most straightforward, easiest claims process I've ever had to go through. Number one, yes, we did get paid, and we got paid in full on the policy. We got paid very expeditiously, without any hassle, and with little to no real claims proof process. It was a very simple, straightforward, and easy claims process. And, no one likes to lose, and it's going to happen statistically from time to time. And, it was a real nice thing to have in the back end, as you said. And, when it's all said and done, I think from the time I, hit the first button on the website to start the claims process, I think I had, the check within probably a couple months, if I'm remembering correctly. And it was as easy as it is to almost apply and get the product on the front end.
That's good to hear. And I know you said earlier, we were talking a little bit before we started the recording, that your firm does different types of work. You do matrimonial, you do personal injury, but your focus is medical malpractice. And I think we all know that medical malpractice cases, not only do they cost the most money, but they also tend to present the most risk because, the way that, especially, with the way that the media has painted medical malpractice cases, it just immediately you start in front of a jury, possibly just a little bit behind. So there's that extra risk factor there. I know when I did that work, it felt that way as well. So especially as it relates to those cases, the products liability cases, can you tell us how does this product, once you have it in place, how does it make you feel? Does it make you feel stronger? Does it make you feel like you have a leg up on the defense? The actual perception when it's there, how do you use it?
So you're absolutely correct. Medical malpractice cases are high stakes, high risk. On the average case, I'll spend anywhere between $75,000 to $125,000, upwards sometimes of $200,000 per case. And, my motto and our mantra to clients and to my team members is that we handle every case as if it's going to go to trial. We don't cut corners. We do what has to be done and needs to be done for the client in the case to make sure that when the insurance company considers, are we going to settle? If the answer is no for some reason, they know we're going to be ready to go to trial. And what does the level insurance product in my back pocket do for the calculation? It definitely gives me that added boost of confidence, and my client as well. That because the client, you got to understand the client's perspective from my experience is that they know they have an attorney who's going to go the distance. So if I'm buying an insurance product, that's telling them there's no corners going to be cut here. I'm going to take your case to the mat. I'm going to go to trial. I'm going to go to verdict if that's what needs to be done. And as far as dealing with defense counsel and insurance adjusters, more than once I've let them know that when they're trying to give me the normal spiel and tactic of, well, you got to consider you're going to spend X more dollars going to trial. And I know you've already spent a lot of money, Paul. Do you want to risk that? And I just very simply and quickly tell them, don't you worry about that. I've got that covered. I have insurance. And usually, they don't believe me at first and they give me like a side look. And, and usually it leads to a very, interesting discussion, frankly. And they're really, surprised and interested. And they all walk away saying, wow, that's really smart. And if I were in your shoes, I would do the same thing is usually what I hear.
It's interesting you say that because one of the things that we have found, it was a surprise to us actually, when we first developed Level Insurance, it really was for the sole purpose of providing that back end protection. But as we started selling the product, we actually got calls from lawyers that were representing insurance companies thanking us for developing the product. And that sounds kind of odd, right? But the reason why they were appreciative was that they were dealing with insurance adjusters who simply were intransigent about trying to settle cases. So the existence of this insurance policy on some of these cases sent a message to the adjuster that this lawyer is not going to cut a single corner. They're going to call their witnesses live. They're going to travel to their depositions. They're going to have the trial technology that they need. And that's going to only increase the value of the case and the exposure to the carrier. And it's actually led to better settlements and better discussion between defense lawyers and their adjuster counterparts. So the fact that you bring this up to defense lawyers is interesting to me because we're starting to hear more and more that lawyers are not just using it as a shield, but they're also using it as a sword.
Yeah, absolutely. I mean, when it's all said and done, me as a plaintiff's attorney, I have a huge responsibility. I have people's lives literally at stake and, trying to get them civil justice. And we're not in an eye for eye society anymore. Our civil justice system ends with our trial jury system, right? And monetary recovery. And the insurance companies, in my experience, approach everything from a very black and white approach, dollar and cent analysis. And when I have the ability to say, listen, you're not going to get me off of my number that I think is the number that needs to be paid because of X, Y, Z. And by the way, I have insurance and I've even offered to send a copy of the policy, to tell them, listen, I'm happy to send you the policy. Go show it to whoever you need because I don't want to hear that normal old school line of argument that, Paul, you really need to consider your expenses. And, do you want to risk losing your expenses? So, it's definitely a sword in that way for sure.
And for the case where you had to make your claim, without telling us specifics about the parties themselves, can you tell us a little bit about the case, how the case went? And, ultimately, were you forced to go to trial because the defense simply wasn't offering enough money? Or did you go to trial because you thought that you could just get a better result? And what type of things did you do, if anything, different in that trial because of the existence of the insurance that you may not have done or may have thought twice about without the insurance?
Yeah, so, I've had probably, I don't even know, 30 to 50 cases. I would say I've taken out the policy and I've been fortunate to only I made a claim once. It was a medical malpractice trial. My best recollection is that we did have two defendants and at least one, if not both of them, refused to consent to settle. So in New Jersey, at least, the doctor's medical malpractice insurance policies have consent clauses. So even if the defense attorney and the insurance company wants to settle, if the doctor says, I do not consent, they have veto power, that case is going to trial. And I think that's, in that particular case, is what really led the case to have to go to trial. It was a normal med mal case, I think lasted 3 to 4 weeks. And, we went into that trial like we always do, locked and loaded. We called all our witnesses, but, the policy was there as a safety net, knowing we're going to try the case like we try every case. And if it doesn't go our way, it's there as a backup. And ultimately, the client was happy, although, we got no cause. They were happy with the way we presented the case. It was actually a gentleman of Egyptian descent, and his wife and his sons were a little concerned, how was the jury going to receive them as being immigrants from Egypt? And, how were we going to ever get justice? And, what really strikes a chord with me is that at the end of the case, the family couldn't have been happier with me and my trial team, because we gave their father and husband's case and legacy a chance for justice. And his story was told, on the witness stand, through our experts, through them. And they really, walked away saying, you know what, you fought like a lion for me. I always remember those comments. And that's just, what we do. And your product, allows us to have another bullet in our chambers when we go into trial and go to war for our clients.
Yeah, I have a lot of respect for it, Paul, because I think that, when you're talking about trial, every good trial lawyer loses cases. You're not a trial lawyer if you're not losing a case or two in front of a jury, because you go in front of a jury, you're always taking a risk at how they're going to perceive your case. And you could be the very best are still going to lose. And that's really what we're setting out to do, is to protect those real trial lawyers, the people who put it all on the line for their clients. Because at the end of the day, sure, you're going to get your money back on your costs, but you spend an unbelievable amount of time and energy on these cases, and not to earn any fee on it is a big risk in and of itself. So all we're trying to do is give you a little bit of protection on part of the investment, but the real investment for you is all the time and the energy and the sweat that you put into these cases for years until you finally get to the end. So give you a lot of credit for all the work that you do.
Yeah, thanks, Judge. I appreciate those sentiments and comments. I really do. And it's the truth. I mean, we approach every case from the get-go like it's, our own family is the client, and we really don't cut corners. And, I started my career doing defense work, medical malpractice, and then transitioned to also doing products liability and some mass tort defense work. And a lot of the people on my team also had defense backgrounds. So we've been there. We know how the defense thinks, how they approach cases. And when I started doing plaintiff's work, I set out to develop a reputation on a few major things. One is when a defense attorney and an insurance company gets a complaint with my name on it and me as a designated trial counsel, that they know a few things immediately. They know that I know what I'm doing. I'm a real medical malpractice lawyer. I know substantively the law. Number two, they know I'm going to spend whatever I need to spend, do whatever I need to do to get the case to the finish line. And a lot of times that means going to trial. And three, they know that I know how to try a case. And, your product is just part and parcel of that mentality and our real model of being a trial lawyer. And, to me, I tell people it's a no-brainer. I've talked to colleagues and other plaintiffs' attorneys that I don't even know, I just run into. And I'm always, advocating and saying, listen, I don't know why anyone wouldn't do it, for essentially, $3,500, you get a $50,000 insurance policy. And to me, it just makes sense for you, the lawyer, and your firm and your client. I have clients who ask me a lot when I first meet with them and go over my retainer, what's this litigation protection insurance business that you're talking about? And when I explain it to them, it gives me a real, I think, advantage if they're shopping around, quote unquote, for attorneys, because I say to them, listen, this is me telling you I'm all in. If it requires taking your case to trial, this is just another thing I can point to tell you we're going to do everything that we're going to need to do and not cut corners.
That's great, man. And as far as this particular case, did you all appeal the case?
We did not actually. After consultation with the family for various reasons, they chose not to appeal, and we ultimately decided not to with the client's consent and their consideration of it.
Well, the reason I ask is that a lot of times we hear lawyers, they ask us the question, do you have to appeal a loss in order to make a claim? And so in your particular case, you did not appeal it, and it is not required to appeal. One thing that is important is that if you appeal it, you continue to get the protection through the appeal and potentially a retrial if you still have enough coverage. But there is no requirement to appeal. And in your particular case, you did not appeal and you were still making the claim and you still got paid.
Yeah, correct. That was my scenario.
Great. All right. Listen, man, thank you so much for taking the time to talk with us. It really is great. It's always good, first of all, to talk to our clients somewhat face to face. It's a good thing for Zoom. And I really appreciate you taking all the time.
My pleasure. And thank you and Larry for everything you guys are doing for plaintiffs' attorneys and our clients. It's really an excellent product, and nice to see you via Zoom. And I know you're jealous that it's 50 degrees in New Jersey today, and it's probably a sweltering 89 with humidity in Miami. So I have that on you, Justin.
It's about 75, which is even better, but I don't want to rub it in.
Good chatting with you. Thanks.
Thanks.